Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover four fundamental questions about property and property law, and today we are talking about the fourth, which is holding interest in property and one of my favorite shared estate cases. The case is O'Brien versus O'Brien, which takes place in a non-community property state, New York, in 1985. Here we come across the interesting question of whether a spouse has claims over the overall assets of another spouse, and particularly their human capital. So the O'Briens, they're husband and wife. They got married in 1971. They were both teachers. Then the husband decided to go to medical school, and the wife supported him throughout the process. In fact, she paid 3/4 of the expenses during medical school. He obtained a license to practice medicine and a surgery residency in 1980, and 2 months after that, he filed for a divorce. So the question in the case is whether the medical license is itself property, which must be divided in a divorce. New York is a marital property state, meaning that equitable division, equitable distribution is the standard used. As we noted in another video, states that adhere to community property principles simply divide property 50-50, making the results more predictable. Equitable division, as we see in New York, allows a court to weigh many factors before making a decision as to how property will be allocated. In determining whether the medical license is property, the O'Brien court looked first at the statutes. The relevant state law defined marital property to be all property acquired during marriage, regardless of the form in which title is held. So the concept of marital property in New York is created by the legislature, not by common law. So there will be things that are covered in the statute which may not typically considered to be property. All right. The court concluded that the medical license was, in fact, property for several reasons. First, pension rights had been previously considered by the court, and they said, well, marriage licenses are similar. But more importantly, the court found that the license was a product of a joint effort in that marriage was an economic partnership. Working spouses like Mrs. O'Brien greatly contribute to the acquisition of licenses, and the license itself creates valuable property rights in terms of money and effort and the lost opportunities spent by Mrs. O'Brien to acquire it. In addition, it gives enhanced learning capacity to its holder, again, speaking to its value as property. The alternate view not adopted by this court is that a license cannot be bought and sold. It's not something that has a market value. It's very personal to one individual and has to be acquired through specific knowledge. But again, the court does not adopt that view. Instead, after determining that the license itself is property, the court has to figure out how to value it. The court could have said that Mrs. O'Brien was only entitled to her contribution, the 3/4 of the amount of sustenance that she contributed to get her husband through medical school. Instead, the court awarded her 40% of the present value of the monetary difference between the average college graduate and the average general surgeon. Weighing all the factors, including the future interest earning capacity of Dr. O'Brien, the court says it's clear that the monetary value shouldn't be limited to her actual contribution. One factor this court does not consider is fault, whether the spouse contributed to the end of a marriage through a bad act. Many states now have no fault divorces, where you can not assign fault to any party, and the equitable division occurs in a manner that completely precludes that consideration. This case happened to predate many of those no fault rules. So this is a great case. It is the only high court state case that decides that medical licenses are property. I think it's an important thing to consider as you think about to what extent property can or should be owned in common. So with that, I will leave it there. I encourage you to contact me on Twitter or through my website, where you can sign up through my mailing list, and I will see you next time.